Good afternoon, everyone. Welcome to Law Sessions. My name is Samuel Senyonjo, and we are still going on with the law of contract. Yesterday, I dealt with consideration, and it got done. I'm still dealing with the elements of that make a valid contract. I began with offer and acceptance. I discussed that in depth. Then I dealt with what I dealt with yesterday. And then today, yesterday I dealt with consideration, and then today I want to deal with capacity to contract. Yes, I'm still doing law of contract. It is very interesting and you need to know about it. Why? Because every day we do contract. Every other time we do contract. So now today I'm going to do capacity to contract. Who has the capacity to contract? I'm going to be answering questions like, what is capacity to contract? Who has the capacity to contract? Like the persons who have the capacity to contract. Who do not have the capacity to contract? Some exceptions, general contract, and the exceptions there too. Then I'm going to summarize with the remedy, or yes, the remedy. I think I explained that, and then I call it. The video is going to be of minutes. So what is capacity to contract? If we talk of capacity to contract, we are meaning the legal capacity to enter into our contract. The legal capacity to enter into a contract. Are you able to enter into a contract or not? That is basically what we mean by capacity to contract. The legal capacity to enter into a contract. If you have your Contracts Act, we are going to deal with Section 11 and Section 12 of the Contracts Act. Section 11 talks about the capacity to contract and the persons that do have capacity to contract. So the capacity to contract, if I talk of capacity to contract, do you have the capacity to contract? Just to know that, the question is, do I have the legal capacity to contract? Can I enter into a contract? Am I in position to enter into a contract or an agreement? Because contract is an agreement. But before we do an agreement, you need to have the capacity to enter into that agreement. Now, these are the persons who can enter into a contract. One, according to Section 11 of the Contracts Act, Cap 2010. Number one, persons who are above the age of 18. They can enter into a contract. Number two, persons of sound mind. They can enter into a contract. Number three, who are not disqualified by the law to enter into a contract. So, of a person, do not forget that I am meaning artificial persons and natural persons. What are natural persons? Me and you. Those with the soul, the spirit, and the body. And if I talk of artificial persons, I'm meaning the corporations, the companies, corporations like the companies, those are called artificial persons. They have the capacity to contract. So in law, if I talk of a person, I'm not only meaning you and me, but I'm meaning even the corporation or our company. So a company has the capacity to contract. He is a person. He is a person, though not natural, but artificial person. So now, capacity to contract. I've said, if you are 18 years and above, you have the capacity to contract. So, these persons have capacity to contract above 18 years. Those of sound mind, if you are of sound mind, you have the capacity to contract. If you are not of sound mind, you do not have the capacity to contract. Persons who are not of sound mind, who are they? Those are the persons who either are drunkards. Drunkards don't have the capacity to contract, number one. Number two, minors. Minors don't have the capacity to contract. We are talking of mental capacity. Mentally, are you in position to contract? So if you're a minor is any person who is below the age of 18. That is number two. And then three, mental patience. If someone is mentally patient, they may be lunatic or insane persons. Insane persons do not have the capacity to contract. That is the general rule. That is the general rule. We have exceptions, like I've been telling you that in every general rule of the so now, lunatics or insane persons or persons mentally incapacitated, they are patient, they cannot enter into a contract, save for the exceptions we shall see hereafter, probably coming week. So, minors, and then mental patients cannot enter into a contract. Why? Mentally, they are not in position to be legally bound. They are not in position, to make a decision. They can't make a decision. Why? They are drunkards. They are intoxicated. So if they are intoxicated, they are not able to make a decision. We are dealing with capacity to contract and a contract law. It is one of the elements of the contract. So, we have like 7 elements of contracts, as I gave them in the first lecture we had. So now, today, I'm dealing with capacity to contract. I've given the 3 persons who can contract, and I've given 3 persons who cannot contract. And if I talk of a person, I'm also meaning the artificial person, that is the companies or corporations. We can talk of partnerships. We can talk of organizations. So those are all persons. They can enter into a contract. Even a government. Even a local government. Those are all persons in law. Why? They are entities. They have the capacity to sue and they have the capacity to be sued. So today, I'm going to deal with minors in regard to capacity to contract. So, who is a minor? A minor is any person who is below the age of 18. If you look at Section 11 of the Contracts Act, a minor is any person who is below the age of 18. But for the issue, for the purpose of contract, a minor, a person who is 16 years of age, can contract. That is even according to Article 35, 4 and 5 of the Constitution. Article 34, 4 and 5 of the Constitution. The Constitution is to the effect that, the provision of the Constitution is the effect that a minor, a person can enter into a contract. They can contract. Now, the definition, who is a minor? You put a minor is a person who is below the age of 18. So if you have any person who is below the age of 18, that is a minor. Before, in common law, they were using the word infant. The minor was referred to as an infant. But as law evolved, an infant, the name was changed to minor. If you are not a minor, you are a majority. So if I'm saying he's a minor, that just know that he's below the age of 18. So a person who's of majority age is the person above the age of 18. So me and you probably who's watching, we attain the majority age, so we can contract. You can enter into a contract, but I'm dealing specifically with minors. What happens is, if you deal with them, what happens is, under what circumstances the minors contract? That is what I'm dealing with today. So the minors the general rule regarding capacity to contract is that every person can contract. That is the general rule in regarding capacity to contract. Every person can contract. They have the ability to contract. That is the general rule. But you have the exceptions. A minor may contract. Under what circumstances may a minor contract? So you're going to be careful as you are dealing with the minors after listening to this, after knowing the law. Because in law, yes, we say that ignorance of the law is not a defense. If you don't know something, but it is written in the law, then it is not a defense. It is up to you. Actually, these laws, we are supposed to know all of them. So if you are ignorant of the same, it is up to you. It is not the duty of court it is not the duty of court, I mean, to get you know. You must be knowing the law because it is there, it is written, it is gazetted. So a minor can contract. Under what circumstances may a minor contract? I'm going to be giving you a principle and a case. I'm going to be giving a principle and a case. And for those of you who are offering law, who are going to or who are going to offer law, please and please read these cases, because if you read the case, you understand more. It is like a Bible and listening to a sermon for you a Christian is. The Bible is there, yes, but if you listen to a sermon, or if you read a certain book that was written on a certain or a particular topic, then you're going to get a deep understanding of that. So in law, we have the law, which is block. So now to understand it, since it is interpreted by courts of law, so we have to read cases, decisions of court, to know how have they talked about this, how have they interpreted this definition. As we go on and on, I'll be teaching what we call constitutional interpretation, and you see how they interpret the constitution, all the agreements, all the provisions. So now, I'm going to be giving a case, and after giving you a case, a principle, I'm going to give you a case. Principle, a case. So now, minors can contract to what we call necessaries or necessities. Necessity goods. For some of you who did commerce in senior one, you've heard about that word. Necessities. What are necessities? These are goods that if they are not there, the minor cannot continue with life. The best goods, they are necessary, they are vital, they are important, they are crucial to their life. I mean, so a contract, one, if the goods are necessities. If they are necessities, then they are bound by the contract. Like, for example, food, shelter, accommodation. Let's give it that. Health, clothing, legal advice. Those are necessities. The minor cannot go without food. They cannot go without education. Education is also an example of a necessity. They need education. They need, these days, transport. It is a necessity. These days, transport is a necessity. And actually, this is very important to note. Courts will look at, it is a case-to-case basis. Like, for example, if you come from a well-off-to-do family, and I come from a peasant family, what I call necessity, what you call necessity may not be necessity to me who comes from a peasant family. So it is a case-to-case basis. The court is going to look at the facts of the case, the family, and probably make a decision. There are some cases we are going to look at and find that if you are a peasant, it is not a necessity to you. So, necessities, minors can contract for necessities. Do you have some cases? let's put down the case of Nash versus Inman. The case of Nash versus Inman. Nash is N-A-S-H versus N-I-N, then man, M-A-N. It is a case of 1908. What happened in this case? We have this miner. They went to a tailor for waistcoats. He made 11 of them, 11 waistcoats. But he failed to pay the money. So thereafter, this tailor went to courts of law and sued this miner. When he sued the miner, the father of the miner came in and argued like this, that the miner has all the clothes they need. They had all the clothes. And two, he's a minor. He was an infant. The father argued that, he argued two, that this is a minor, is below 18. And then two, that he has all the supply. So the courts of law held that, they held coming up with a principle that it is incumbent upon the seller to prove that the miner indeed needed it, that the miner indeed never had the supply that was given to him. So we have a principle here that before you say to a miner, you have to prove that they do not have the supply. So the court held in favor of the miner that the miner was not liable. He was a miner, and two, he had the necessaries. Like I've told you that it is a case-to-case basis because these are clothes. But they said no, the miner had all he wanted. I mean, he had all the clothes. The father had supplied him. He had all the clothes he needed. So this was as if a luxury. So the court held in favor of the miner. He was not liable and he never paid. So that is an example. It is an example of a luxury and necessities. Clothes are basic needs. They are necessities. But in this case, there were 11 of them, waistcoats. The court ruled in favor of the miner that he was not liable. Actually, even if he lies to you that I'm say 18, they are not liable. Even if they lie to you and you go to courts of law claiming for damages or claiming for any remedies, the courts of law will disregard that. They are going to decide to give a decision in favor of the miner. So miner can contract if it is a necessity. But if it is a luxury, then it is going to be held in favor of a miner. I'm going to give you another principle. That is number one, necessity. Then number two, contract of service. Contract for service. What is contract for service? Contract for service is working, like job. Contract for service, employer-employee relationship. So now, a miner can contract. Number one was for necessity, and number two, where a miner may contract is contract for service. They can enter into a contract to provide service to other persons, employers. Here, they are going to be liable by the terms of the contract. We shall study employment law in the near future. Labor law, actually, we call it labor law. In the near future, we shall study about labor law. But let me give just a glimpse of it. A miner can enter into a contract for service if it is not hazardous to the health of the miner. But if it affects the health of the miner, they cannot enter into the contract. And if the terms are good to the miner, for example, the miners are supposed to do what we call light works. Light, something light. You cannot employ them in mines and those big plantations. You cannot, those big machines where there is dust and all that noise. No, they are not supposed to be employed therein. They are supposed to be given light works. So if the miner is given a light work, then they can enter into a contract and they are bound by that contract. I have, I think, like 2 cases to the effect. Number 1 is the case of Roberts versus Gray. This is a locus classicus case. Roberts versus Gray. Roberts, I think you know the spelling, versus Gray. It is a case of 1913 KB at page 52. What is KB? If I talk of KB, that is Queen's bench. I mean King's bench. We have QB and KB. This is for England. During the rule of a lady, it could be QB, Queen's bench. And during the rule of a gentleman, it could be KB, King's bench. So you write 1913. I told you after writing the years, we do close the brackets. You put KB at page 520. It is the case of Roberts versus Gray. What happened in this case? A miner, Gray, entered into a contract with Roberts. Roberts was a very prominent player, very prominent by then, in that year, in the 19. So now they entered into a contract. Roberts was supposed to take Gray for a tour to instruct him, because Gray wanted to become a player, international player. So they went. They were supposed to go. So they entered into a contract. This is a prominent person, and he was supposed to be paid. He was supposed to instruct him here and there in order for the same to become a player. So before that time, on the day they were supposed to go, this miner refused to go with Roberts. He refused to go with him for that tour. It was a national tour, and he refused. So what Roberts did, he sued the miner for breach of contract. But remember, the general is that miners do not contract. Why? Because they don't have the capacity. So Roberts went to courts of law for breach of contract. This miner argued that the defense, or the defendant, or the miner argued that he was a miner, hence he was not bound by the contract. The courts of law held that, they held in favor of the plaintiff, or Mr. Roberts, that, look here, this was for your advantage. It is a job. You wanted to become a prominent player, and this is a prominent player. He was going to instruct you. It was for your benefit. He was developing your talent. And then you cannot argue that I'm a minor. It was for your benefit. It is a career. So you are liable. So a minor in this case was found liable for breaching the contract. He breached the contract when he refused to go. And Roberts was compensated for the same. That is the case of Roberts versus Gray. You can also put down the case of Kerement versus London North West Railway. Kerement, Clement versus London, London, North West Railway. It is a case of 1894. Volume 2. You do 1894. You close the brackets. You put 2 as in 2. Not in figures. Then QB, Queen's bench. You just put Q, capital letter Q, and B at page 482. In this case of Kerement, the miner Kerement wanted to become an international boxer. So he entered into a contract with the defendant. And at a certain period, he breached the contract. He wanted to become an international boxer. So he entered into a contract for training. They were supposed to be trained. So he entered into a contract. But then he breached the contract. He did not fulfill the conditions of the contract. So they went to courts of law. When they went to courts of law, when he was sued, he argued the same thing. Leirwe. Why? After W-A-Y. So, he was sued. When he was sued, what happened? He was arguing that I'm a minor. I'm below the age of 18. It was held, like in the case of Roberts, that he was bound by the contract. Why? This is a career. This is not anything. This is not a luxury. This contract was binding on him. Because why? It was a career. It was for the benefit of the minor. Yes, Atta, thank you. It was for the benefit of the minor. And that is the case of Clement versus Northwest Leire. However, take this. Even if it is for the benefit of the minor, not always that courts will give decisions against the minor. Not all benefits, and I mean it is beneficial to the minor, not that the court is going to hold in the favor of the other parties. No, it is a case-to-case basis. Like in the case of, this is a locus classicus case. For you who want to offer law, you're going to read it. The case is FAWCETT versus SMETHURST It is a case of 1914 at page 84. It was said that not all contracts are binding to the minor just because they were beneficial to the minor. Some of the contracts may be beneficial, but not necessary, and they are not binding to the minor. That is the case of Fawcett versus Smethurst. It is a case of 1914 at page 84. So it is a case-to-case basis. We do not, yes, we have the general rule, but it is a case-to-case basis. Hope we are clear on that. And number 3, I'm giving under what circumstances may a minor be liable. I've given contract for service. I've given necessaries. And number 3, in acquisition of property. In acquisition of property, a minor is going to be liable. Which property? Either a lease or it may be shares in a company or in partnerships. So, if they are acquiring property, they cannot avoid the duties. The rights and duties accompany there too. So, if you buy shares in a company, you are supposed to pay for them. Like if they make call on shares. What is call on shares? Call on shares happens where we've given you shares. You know, if we give shares, this is company law, we shall study it in the future. It is kind of complicated and people fear it. But let me just give this for the purpose of understanding what is call on shares and owning property in companies pertaining minors. Now, if we issue out shares, you take some shares, we issue shares, or we allot shares to you, they are issued to you, you take them up, you become a shareholder in a company, but you are a minor. If we make call on shares, what is call on shares? Call on shares is like a request that kindly please pay for your shares. Because if we issue them to you, it is not mandatory that you have to pay for them at that particular time. No. If we issue shares, you may be having them, you are a shareholder, but you have not yet paid for them. Because in companies, it is not mandatory that you have to pay for them at once. No. You can even take 5 years when you've not paid for the shares. So if you are a minor, we gave you shares, you are a shareholder, and we make call on shares, a request that you have to pay for shares. What happens? You got to pay for them. You are liable to pay for them. If you do not pay for them, then you are liable. We can kick you out. We can sell them. We can forfeit them. We use the word forfeiture. They can be forfeited. If we call you to pay for them and you do not, then we can forfeit the shares. So you are bound by the agreement to pay for the shares. So, number 3, in the acquisition of property, you are supposed to pay for it. Like leases. You cannot say that I'm not going to pay for leases. Why? Because I'm a minor. No. You cannot say that. That because I'm a minor, I'm not going to pay for the lease. No. You are bound. If you are in partnership, you have to do your contribution. If you are in partnership, you got to do your contribution. So in acquisition of property, a minor is liable. Is liable to fulfill the terms, the conditions, and the duties. Hope we are clear. If you have your children, you bought them shares, they are supposed to pay. If you die, God forbid, if you die, and you have shares in a company, you've been admitted there to in the company, you are supposed to pay for them. They are supposed to pay for them, because if you die and they're the beneficiaries, they are supposed to pay for them if at all you left some shares that were not paid for. So, I've given 3 reasons, and that is the case of West. The case to the effect or to that principle is that of West Leire versus the apostrophe Makaelo. West Leire versus apostrophe Makaelo. It is a case of 1850. The minor, in this case, the minor wanted to run away from the responsibility of the insurance company, that he was not bound. Yet he was working in a company. He was held to be liable. Why? Because he was working. The terms of a contract were binding to him. He was working for a company. However, let me give this comment. If you are in a company or in partnership, before you attain the age of majority, you can run out of the responsibility. You can repudiate before you attain the age of majority. So you can repudiate the responsibilities there too. Before you attain majority, you can say, let me repudiate. Let me go out of this contract. That is about the minors. So now, if I enter into a contract, those are 3 elements. I'm done with the 3 elements or circumstances under which minor may contract. But look here, if I enter into a contract with a minor, I'm liable. If I do not deliver, I'm liable. The minor can sue and be compensated or given damages or specific performance. But you cannot sue the minor. Even if they lied to you the age, they are not supposed to be liable. I'm liable. And that is what we call voidable contract. I labored to explain what is a voidable contract, though I'm going to repeat the same even today. So, if you entered into a contract with a minor, you are liable. You, one of majority age, you are liable. The minor is not liable, even if they lied to you the years. There is this interesting case I'm going to give you. It is a case of Mercantile Union versus Ball. Mercantile Union versus Ball. And I'm going to give you 3 void contracts. They are what we call void contracts. We have voidable contracts, we have valid contracts, we have valid, we have void, we have voidable contract. So these contracts, I'm going to give you, there are three. They are void ab initio. You cannot enforce them in courts of law. You cannot enforce them. So if you contracted with a minor, you cannot enforce them. And I'm going to begin with that case of mercantile union versus Ball. It is on business. It is on commerce. It is on trading contracts. The principle is trading contracts. Under trading contracts, the minors are not liable. If I gave him maybe some goods to walk around, to sell them, and probably they sell and they don't give me the money, I cannot sue them. Why? They are minors. So that contract is trading contract. The trading contract is void ab initio. It is void. I cannot enforce it. It is not binding on the minor. Hope we are very clear on that. If I gave them goods to walk around, they are not going to be liable. Why? Because they are minor. And that is the case of mercantile union versus Ball. Mercantile is MECHA Ball. BALL. It is a case of 1937. This was a contract for the minor entered into a contract with a company, and it is a case of 1937. They entered into a contract for hire purchase. He had a lorry, a vehicle. So after hiring a vehicle, they failed to pay for it under the agreement of hire purchase. So when they failed to pay, the plaintiffs sued the minor in courts of law for specific performance that you have to pay. They had to pay, and probably the damages. So when they went to courts of law, the company argued that this was for the benefit of the minor. This was for the benefit of the minor. And the holding of the court was that it is illegal, it is unlawful for any person to enter into such a contract for business, a commercial contract. It is unlawful, and the minor was not liable to pay. Why? Was a minor. They cannot enter into such a contract. If it is a business or a trading contract, they are not liable. They are not supposed to pay. That is number one. Any contract, so I think we are enlightened on that. If you enter, if you deal in cars and you are hiring these specials, and they take your car for a week, they bring it back, they don't pay you, they are minors, just chill and rest. Because why? You cannot enforce that contract even if they written somewhere, even if they lie to you. Yes, that is the common law principle. So that is number one. Number two, loan. That is the case of LESRLI versus Shale. Shale is SHEIL. In that contract, a minor entered into a contract for a loan, but he failed to pay that loan. So he was sued. They wanted him to pay the loan. The courts of law held that no, a minor cannot enter into a contract for a loan. A minor is not supposed to enter into that contract. So the minor was exonerated, and it was held in the favor of the minor. So be careful. If you borrow a minor and they don't pay you, maybe convince them or do something else. but they are not liable in contract, law of contract. Why? Because they are minor. And number last, 3, contracts which are void. Contract for supply of luxury goods. If you enter into a contract for supply of any luxury good, just know, or a service, just know, if they don't pay you, just chill. Why? They are minors. The contract is not binding, but remember I told you that in certain cases, some things are luxury, others are not. Like you've seen this international boxer. If I'm a peasant and my minor went for such a service, I may not be liable because I'm a peasant. That is something luxury. It is not a basic. But if it is a well-off-to-do family, I may be liable. Why? It is a well-off-to-do family. So, if you enter into a contract for supply of goods or services, but they are luxury, then the minors may not be liable. Those are called void contracts. And we have what we call voidable contracts. What are voidable contracts? I explained, labored, that voidable contracts can be avoided at the expense of the person who is not in breach. So, it is voidable. If the minor does not avoid it, then it is binding. But if he chooses to repudiate, then it cannot be enforced against the minor. So we have voidable contracts. And under the voidable contracts, those are the contracts I've talked about of lease. It is a voidable contract. They can repudiate the contract before they attain the age of majority. In companies and shares, all that, they can repudiate before they attain the age of majority. And then those partnerships, in partnership, they can repudiate. So it is voidable. The minor can avoid. A person who is not at a breach can avoid, but the other person cannot, of course, avoid their contract. So they are voidable at the expense of the minor. The minor may choose to avoid the contract before they attain the age of majority. So we have void contracts, valid contracts, voidable contracts. I've discussed voidable contracts and I've discussed void contracts. I may comment about valid contracts. Those for necessities are valid contracts. Number 2, contract for service is a valid contract. And number 3, acquisition of property is a valid contract. You can enforce them against the minor. And now, we may ask, what are the remedies? If I entered into a contract with the minor, what can I do? What should I do? Well, in equity, you have a remedy. A remedy is called restitution. Like, for example, if you entered into a contract and you sold your property to a minor, remember you cannot sue them. You cannot sue them because they are minors. But they can restore your property. If the court deems it fit or equitable or just, they can restore your property back to you. We call it restitution. There is a maxim. I mean, not a maxim. I mean a Latin maxim. Restitution integrum. Restitution is to restore. They can restore that property back to you. That is the remedy you have. If you sold the property, they lied to you, they were minors, you cannot enforce it, you can restore that property back to you. That is one remedy. They can restore it back to you if courts of law deems it fit or equitable or just. And there is what we call that ratification. Ratification does not apply What is ratification? Ratification is when I ratify. Wow. I can ratify. I can correct the mistake. If I correct the mistake, then it is ratified. You cannot ratify anything with a minor, even if they attain the age of majority. However, you can make a fresh contract with them. If they attain the age of majority, you can then make a new, probably, agreement. But they cannot ratify it. Why? Because it was made when they were still minors. So I think you can add that on your vocabulary, and you begin calling some persons minor. You're a minor, you cannot contract. You're a major, you're majority age, you can contract. You can, in your vocabularies, you can add such words: restitution integrum, meaning restoring a person and they go back to their former position. You can add that in your language, your vocabulary, and it becomes your legal language. It is so interesting. On Monday we are going to be handling the drunkards. We are going to be handling those of mental incapacity, and we shall get done with capacity to contract. Thank you very much for listening this morning, for watching. My name is Samuel Senyonjo. Have a blessed day. Bye-bye.